We are now only weeks away, or perhaps even sooner, from a potentially landmark Second Amendment decision by the Supreme Court since the Bruen case. The court is expected to release its decision in Woolford v. Lopez before the end of this term, which falls in late June or early July. This ruling will directly build on Bruen and address the pushback from states that has emerged since that decision. This case is not simply another routine challenge because other major Second Amendment cases, such as Benson v. D.C., are now on hold pending the Supreme Court's guidance. That means the court could be about to answer questions affecting magazine restrictions, carry limitations, sensitive location laws, and even hardware regulations, depending on how they interpret Bruen and instruct lower courts to apply it going forward. Woolford v. Lopez involves Hawaii's response to the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruen. After Bruen struck down New York's May-issue concealed carry permit system, Hawaii enacted new legislation. Under this law, concealed carry permit holders cannot carry firearms on private property open to the public without prior express permission from the property owner. This effectively reverses the usual rule and has been described by many gun rights advocates as a de facto carry ban. Traditionally, lawful carry has been permitted unless a property owner explicitly prohibited it or displayed signage stating that concealed firearms were not allowed. Hawaii adopted the opposite approach. Under Hawaii's framework, carrying a firearm is forbidden on private property that is open to the public unless the owner has first granted clear permission. In other words, the default position is no longer permission to carry. Instead, authorization must be given before a firearm may be carried at that location. The Ninth Circuit reviewed the measure and upheld Hawaii's law. That ruling is now under examination by the Supreme Court. At first glance, the dispute may appear to center on property rights. However, the broader issue reaches much further. The key question is whether states can effectively eliminate the right to keep and bear arms through regulatory changes after disagreeing with the outcome of Bruen. Those challenging the law argue that if government authorities can declare nearly all private property accessible to the public off limits, then the right recognized in Bruen loses much of its practical value. Their position is that a constitutional right existing only in theory provides little real protection. That concern appeared to receive significant attention from the justices during oral arguments in Woolford. Throughout those proceedings, several members of the Supreme Court seemed doubtful of Hawaii's position. The justices repeatedly examined whether the law operates in practice as an almost complete prohibition on carrying firearms. Hawaii maintained that lawful carry remains possible in certain places and under specific circumstances. Even so, a number of justices appeared unconvinced by that argument. The court also questioned Hawaii's reliance on historical comparisons. Several justices challenged whether the examples cited by the state were relevant to the issue, whether they involved discriminatory practices, or whether they differed substantially from the restrictions Hawaii currently imposes. A central issue during the arguments appeared to be whether the state was truly safeguarding property rights, or whether it had created an alternative mechanism in response to a ruling it did not support after Bruen. Based on the oral arguments, Hawaii still appears likely to lose the case. The larger issue is not necessarily whether the state loses, but how expansive the Supreme Court's opinion will be. The court could issue a narrowly tailored decision directed only at Hawaii's law. It could also release a broader ruling that reinforces how Bruen's text, history, and tradition framework must be applied in future cases, particularly in light of how lower courts have responded since Bruen was decided. That possibility brings cases such as Benson into focus and increases the significance of the upcoming Woolford decision. Recently, the D.C. Court of Appeals approved a rehearing en banc in the Benson v. D.C. magazine ban challenge. Benson previously produced one of the most significant magazine ban rulings seen after Bruen. A panel struck down D.C.'s magazine restriction and also vacated several related convictions. Later, however, the full D.C. court intervened. The original ruling was vacated, and the case was scheduled for reconsideration en banc. For the moment, that rehearing has been placed on hold by the court. The rehearing was recently paused because the court wants to wait for the Supreme Court's decisions in Woolford and Hawani. The judges want to review that guidance and the legal framework it provides before proceeding further with the Benson case. That development strongly suggests the D.C. Court of Appeals believes the Woolford ruling could significantly influence how future Second Amendment cases are examined. This is the point many observers may overlook. Woolford is not a magazine ban dispute, nor is it a hardware-related challenge. Even so, the decision may establish how rigorously lower courts must apply the Bruen standard in the years ahead. That is precisely why the Benson Court is waiting. The D.C. Court of Appeals appears to recognize that the Supreme Court may soon offer additional direction regarding historical analogs, sensitive place limitations, public carry regulations, government obligations under Bruen, and the method courts should use when evaluating modern firearms restrictions. Each of those issues is relevant to Benson. Any clarification from the Supreme Court could influence the eventual outcome of that case. When the Wolford decision is released, several key areas will draw attention. The first is the strength of the court's reaffirmation of Bruin. The second is how strictly the justices evaluate historical analogs when determining whether modern restrictions are constitutional. The third is whether the opinion is written broadly enough to extend beyond carry regulations and apply to other Second Amendment disputes. If the court issues a strong ruling that reinforces Bruin and addresses concerns surrounding how some lower courts have responded to that decision, the effects could be immediate. Cases involving magazine bans, rifle bans, sensitive place restrictions in other states, carry limitations, and additional Second Amendment challenges could all be affected. The current stage of this Supreme Court term is therefore especially significant. The Wolford ruling is expected no later than the next few weeks. At the same time, major Second Amendment cases, such as Benson, remain paused while courts await direction from the Supreme Court. As a result, Wolford could ultimately carry consequences that reach far beyond Hawaii's concealed carry law enacted after Bruin. The decision may help determine how courts across the nation evaluate Second Amendment claims and could directly shape future litigation involving magazine bans, including cases such as Benson. With the Supreme Court's term approaching its conclusion, the wait for answers is likely nearing its end. Soon, there should be a clearer picture of how the court intends to handle Second Amendment cases moving forward, and what broader effects may result from the ruling. For now, attention remains focused on Wolford. The decision is expected soon, and once it arrives, its wider impact will begin to come into focus. If you found this report informative, be sure to follow for future updates and continued coverage as new developments emerge.